Welcome back to Law and Crime Live on the Crime and Investigation channel. Thank you to all those loyal viewers for joining us. If you are just joining us, we are covering the Tex McIver trial. This is an Atlanta attorney who is accused of murdering his wife. The prosecution says that he shot and killed her intentionally when he was in the back seat of a car. He says he was sleeping. He had a gun in his lap because he was scared of the surrounding area. And when he jolted awake, he accidentally killed her. I'd like to welcome two guests to the studio. I'm very pleased to have you. And these are two men who know each other very well for a long time. Sanford Rubenstein, you're a prominent civil rights attorney here in New York. And Arthur Aidala, you're a criminal defense attorney. You used to be a Fox News contributor, so I'm sure people are very familiar with you.
Everyone knows Sandy Rubenstein.
Yeah,
he's legendary nationally. You know, I'm just a little kid from Brooklyn, New York. But Sandy's the man.
Where are you from?
Very skilled trial lawyer, born in Brooklyn.
Brooklyn, too?
You got two Brooklyn boys
But
here.
you didn't know each other growing up?
No, I'm a lot older than he is.
Just in the courtroom?
Right, just in the courtroom. We've actually had some great cases together where we were adversaries and we were able to work things out where both of our clients were pleased.
And I'd love to see that play out here, so I'm going to ask you to take opposite sides of the issue. There is this proposition by the prosecution that the jurors be allowed to fire this gun to see if it's possible that Tex McIver could have accidentally fired it when he was sleeping and woke up. Is that a good idea, Sanford?
I'll take the prosecutor's side on this.
Okay,
Bottom
you go first.
line
You got the
is,
choice.
it's demonstrative evidence. This prosecution wants to show this couldn't have happened by accident, that it was too difficult to just have this gun just go off. And I think that's why they want the jury to see the gun. And I think the judge will allow it.
But Arthur, isn't this like the O.J. Simpson trial? Couldn't it backfire, pun intended here?
Well, it obviously, whoever is making this request feels confident that the juror is going to be on their side. It's interesting because when I lecture at law schools, this is one of the scenarios, and instead of the husband shooting the wife once, he shoots her twice. And what I do is I actually light off a firecracker in the courtroom, in the classroom, to show them that when you get startled and when you get scared, how your finger could just react and your body could just freeze up like that. So it's in the jurors, if the judge allows it, it'll be in the jurors' hands to use their common sense.
You know, said like a true defense lawyer. But the bottom line here is you got to look at other factors in this case also, particularly motive. And that's very significant here. His lack of income, the fact that her death made him $4 million more wealthy than he was before she died. So I think as important as the gun is, the issue of motive here is what's going to turn the jury in this case.
But we've also seen this evidence that he was going to change his whole will and give the entire estate over to his godson. Does that destroy the motive or no, because he wouldn't lose that money until he's dead?
And who knows if he's in cahoots with his godson. My understanding is
well,
that
the godson's 12 years old, so.
Oh, okay. So then maybe not.
Highly doubt
My
that.
understanding is the jury made this request, and jurors often make requests to go to a crime scene to see things with their own eyes because the slick lawyering sometimes can get you down the wrong path, and the realism, the reality of let's see how powerful you need to pull this trigger.
You're talking about what the jurors
I'm
doing
talking about the jurors themselves using their common sense.
And the truth is, you never know what a jury's going to do. My favorite story about juries: the lawyer has a question from the jury. Jury's out. Can we give more than the plaintiff asked for? And the plaintiff's lawyer's thrilled. Wow, I'm going to get a windfall. Jury comes back, defendant's verdict. So the lawyer says to the juror, how come you asked that question? Oh, a jury just wanted to know. So you really never know what's in the minds of the jury until after the verdict's in.
Yeah, but we saw with the O.J. Simpson trial, it was a total boggle for the prosecution to have O.J. try on that glove because it didn't fit, and a lot of people think that led to his acquittal in large part.
And, you know, I think Chris Darden, who was the prosecutor who did that, is on tape 100 times, obviously rethinking that decision. So these are calculated risks. You know, when we do what we're doing right now, we are commenting about what we see on the screen and in the courtroom. There are so many decisions that go on behind the scenes. There are so many decisions, strategic decisions that go on in the law offices. And the only thing you can do is be prepared. So the lawyers had to be prepared that the jurors may ask this question. And I don't think it's such an easy answer for the judge to say, yes, I'm going to let you do it, or no, I'm not going to let you do it. He's going to have to look at the case law and look at precedent and see whether it's appropriate to allow them to fire.
Now, if they do it, do they have to show the jurors what it's like to fire it cocked versus uncocked?
Right. I would argue
part
that.
Of the issue.
I would definitely argue that, yes, Judge, if we're going to do this, then we have to make it as close to the scenario that at least the defense is saying as possible.
Yeah. Now, they brought up earlier today about the fact that the defendant had been drinking. He had some wine. How does that factor into the analysis of whether or not he was able to fire this gun when he jolted out of his sleep, considering there's also been a lot of mention that he was a gun aficionado, that he was very careful about gun safety. So there's some doubt there over how could he have accidentally fired a gun.
Well,
does the alcohol factor in?
Well, first of all, that's why they brought all the guns into the courtroom. They wanted to show how many guns, over 40 guns that he had in his possession in his different homes. So they wanted to show that he was an expert in guns. In terms of the alcohol, we'll see how that plays out.
Well, if it's pro-defendant, you'll call an expert and say that the alcohol and the effect it has on you and dulling your senses and may have made him forget to put the safety on, or maybe he's that intimidated in those surroundings and the alcohol enhances that intimidation. He keeps the gun cocked, which makes it easier to fire. So those are all issues, again, that go into the strategy of the case by the lawyers.
And the other piece is the alcohol, from the prosecution's point of view, may be shown to show that, well, he needed a few drinks before he actually shot and killed her.
Yeah, well, you mentioned something about a case that you had handled where there were 2 shots fired. The fact that there was 1 shot fired, is that more indicative of this was an accident? And the fact that it was fired into her back and not into her head or an area that could have immediately killed her, does that support an accident?
I definitely think it would. I mean, in terms of, ladies and gentlemen, my client is a lawyer. He's an intelligent person. If he really wanted to execute his wife and make it look like an accident, there were much better ways of doing that than sitting in the back of the car shooting through the back of the.
And obviously, it's harder to prove 2 shots are an accident than 1.
Sure.
So the fact of the matter is, the fact that it's 1 shot. Look, he's sitting in the back. She's sitting in the front. He shoots from the back to the front, and her back kills her. I mean, that's serious stuff.
Sure, there's a lot of reasonable doubt in this case. Let's toss back to court now, and we are hearing from a firearms expert who is on the stand.
Science and biology from the University of West Georgia with a minor in criminology. Once entering the GBI, I completed a year-long training program which consisted of multiple blocks of instruction. Everything from history, manufacturing, function, all the way to forensic subdisciplines. My microscopy training was conducted through the GBI and also through the National Forensic Science and Technology Center. And I was sent also to New England to actually go tour firearms manufacturing plants to get an idea of the manufacturing processes that result in a completed firearm. Once I completed the initial year-long training program, I went into a period of approximately 6 months of supervised casework where I worked directly under the supervision of a senior scientist performing the duties of a firearms examiner. Once I got my independent letter, that was after the 6-month period. From then on, we do continuing training. It might be armorers courses, it may be forensic conferences, workshops, something of that nature.
Okay. What is what's the phrase again? You're training the
Microscopy.
microscopy. Say it one more time for me.
Microscopy.
Microscopy. I'm gonna get that down tonight. Tell the jurors, what is that?
So that's the process of the actual comparison that I do. I use a comparison microscope, which is essentially 2 compound microscopes connected by an optical bridge. This allows me to view 2 specimens, 2 bullets or 2 cartridge cases under the same lighting and magnification. What I see is going to be the 2 samples divided with what we call a hairline, and that's the divider between left and right. I can move that hairline back and forth, I can superimpose the images, but what I'm looking for when I'm conducting this microscopy is the agreement of class and individual characteristics. Now, class characteristics are intentional characteristics by the manufacturer that indicate the design of the firearm. So, for example, the amount of lands and grooves in the barrel, which we refer to, that's called rifling. Rifling is a series of grooves cut into a barrel with
So that's a firearms expert, and what he's doing is he's establishing that the bullet that struck Diane McIver is the one that was fired from Tex McIver's gun. This is something that has to be causally established in court. We will be back with more of his live testimony after this, so please stay with us on the Law and Crime Investigation, Law and Crime Live. Welcome back to Law and Crime Live. If you're just joining us, we are covering the Tex McIver case. This is an Atlanta attorney accused of killing his wife intentionally, though he says it was a freak accident. When they were driving in the car, he was holding a gun because he says he was scared of the surrounding area. And when he fell asleep, he said he woke up and accidentally shot her. Well, they're about to go to lunch right now, so I'd like to come here into the studio and talk with my guests. I'm here with Arthur Aidala. He's a criminal defense attorney, and Sanford Rubenstein, a civil rights attorney. Arthur, we just saw a firearms expert on the stand. He has to establish that this bullet came from the gun. But that's undisputed. We know that. Why is this necessary?
Sometimes prosecutors, well, first of all, legally they have to do this. They have to check off the box. Now, you could do something called stipulate. You can just go over to the defense attorney and say, you want to just stipulate that, meaning both sides agree. They just read a piece of paper to the jury and say, ladies and gentlemen of the jury, instead of calling an expert, we're just, both sides are agreeing that this bullet that was found at the crime scene, or these bullets, came from this gun. Or, well, it is in this case, it's this bullet, came from this gun. And it's nice and quick and easy. However,
why not do that then here?
Because
just to
a lot
save
of
everybody
times
the time.
right, well, that would be wonderful, but the prosecutors they want to get the jury involved and engaged and have them. Now, we're only hearing right now about the comparison of the bullets. They may go in with this expert as to the pounds per square inch that you need to pull the trigger. So they're leading off with the microscope test, which is they take the gun at the crime scene, they fire it. That bullet is recovered, obviously, from their lab. They take the other bullet that's discovered by crime, and they put it under a microscope. One's on one side, one's on the other, and there's something called lands and grooves. That's what makes the spiral inside the barrel of a gun that makes the bullet come out in a spiral, like a spiral football. And those are all unique markings. So because of those markings, they can tell you that this bullet came from this gun. And it sounds fancy, and it sounds good. Now, if they may go to the next level of, okay, let's talk about this gun itself and how it fires, et cetera, which is very relevant to the issue in this case.
There wasn't a lot of
Sandy,
though. There wasn't a lot of testing of the gun residue, okay, on the gun, because the crime he didn't do it. Was that a big mistake, or does it not matter?
There's a conviction. So the conviction gets upheld. So
To avoid an appeal.
The prosecutor has to put this in, whether there was an attempt to do it amicably with a stipulation, who knows. But they got to put it in, not the most exciting part of this case.
Let me ask you a question. Tex McIver, one of the first things that he does when he gets to the hospital, while he's waiting to see if his wife's going to live, is he calls an attorney down there because he says, this is not going to look good for me. Then later on, he decides to give an interview to police. Why, if he had already hired an attorney, did he do that interview with police? Wouldn't he know, as an attorney himself, that the prosecution was going to hone in on everything he said during that interview and try to misconstrue or take out of context anything that looks suspicious?
Sometimes people are not as smart as they think they are. I think in that interview, he's also trying to use his defense that he was worth more money than her, he was worth $2.5 million, which is contested by the prosecution, who claims she called the shots when it came to money, and that he was in financial straits. So I think he was trying to use that interview as a trial before the trial in a court of public opinion. But the fact of the matter is, these interviews are dangerous, they can backfire, and I would never advise a client, after they've been in a position where they know they very well may be charged with a crime, to go speak on the press.
You're smiling about him saying people sometimes aren't as smart as they think.
Right.
What about the fact that this guy tried to tamper with witnesses after, that he called people, told them to erase voicemails, to change their stories. He told the eyewitness to say she wasn't even in the car, and he's an attorney.
So you're correct. And when you go back and say about saying, people don't always listen to their lawyers, just to tie it into current events, I believe a very famous lawyer by the name of John Dowd just said he was stepping away from representing a man who's in charge of the White House by saying my client is not listening, taking my advice. And that sometimes happens. And I will tell you, in my retainer agreement, it says that I am in charge of the strategy of the case. And if the client disagrees with me, I could fire the client. So under these circumstances, of course, Sandy, what he's saying is correct. You tell the guy, listen, your wife is still in the hospital. Let's see how she recovers. There's no need for you to give a statement to anybody. Let's lower the temperature. Let's slow things down and see how things progress. Tampering with evidence is another crime. Why would anyone in their right mind do that unless they were in their right mind?
And he was charged with 3 counts of that. Let's watch a package recounting the actions he took after his wife died.
McIver says a gun he was holding discharged accidentally. The bullet struck and killed his wife, Diane. The state is trying him for murder and witness tampering. Danny Jo Carter was driving the car when the gun went off. She says the defendant asked her to tell a different story after they rushed Diane McIver into the emergency room.
Anything else?
You just need to say you came down here as a friend of the family. I said, Tex, I just drove you into the emergency room.
And then did he say something in response to that?
He looked at me and he says, well, they don't know that. Well, that took my breath away.
Also in the emergency room, nurses said the defendant told different versions of how the shooting happened.
I heard him say, and this is what I heard, and it was in passing. I was passing through that I was cleaning my gun in the bathroom and I shot her.
I'm sorry.
I was cleaning my gun in the bathroom and I shot her.
And you heard him say that?
Yes, from him, not from anybody else.
He said to me, it was an accident. I had the gun in the back seat and it just went off and it was an accident.
Nurse after nurse testified about hearing the defendant's bizarre statements and behaviors.
The first words that I vividly remember was to tell them, and then it was like a softer, this is what you're going to tell them, as I was like walking past.
Okay.
So it was like more of a conversation that I was hearing, not like just a one-shot term.
Did you linger such that you could hear?
No, I asked Alicia Redding to position herself that she could further evaluate if I had heard correctly.
Okay. And do you know whether or not she actually did that?
I believe that she did.
Did you tell Alicia to contact the police?
I told her that she needed to speak with the police if, in fact, she heard anything.
That same nurse admitted there was a lot of gossip in the ER.
And some of the nurses in the ER, some of the techs, the people you were talking with, that you heard, were saying, he's going to get off because he has money.
That is correct.
That's what the nurses were saying. Just like OJ got off because he had money.
That is what was said by one of the techs.
Defense attorneys used that and other tidbits to attack the credibility of the nurses. But it still doesn't explain away that Danny Jo Carter felt pressured to lie. This is Aaron Keller for the Law and Crime Network.
And I'm here with my guests, Arthur Aidala, a criminal defense attorney, Sanford Rubenstein, civil rights attorney. Let's go through these charges because it's interesting. What happened was he was charged with the involuntary manslaughter. When he started doing these tampering thing that police say, then all of a sudden we see elevated charges to murder. Why is that, Sanford?
Well, I think you may have also seen the charges and in a grand jury, and the grand jury came back with the elevated charges. And that's probably what happened here. Once the investigation was completed, there were more charges than there were initially.
But is that because he started to look suspicious, Arthur, when he started asking these witnesses to lie?
There's that old expression, the cover-up sometimes is worse than the crime. And the biggest example in modern society would probably be Martha Stewart, who ultimately was found not guilty of doing anything wrong except lying about what she didn't do wrong to federal authorities, and she wound up going to prison for that. So often, human nature, that's why there's the other expression, the criminal always returns to the scene of the crime. There's this instinct to talk, to cover up, I'm going to fix it. I don't need a lawyer, I'm going to fix it, and that usually puts them deeper in the soup.
And here we have a lawyer, which demonstrates the fact that the old adage, a lawyer who represents himself hasn't asked for a client, is very true.
This kid's
and here he's trying to mitigate what happened, and he realized maybe he shouldn't have done the press. He never should have opened his mouth in the first place.
You know what? I want to go into the criminal returning to the scene. That's interesting. I have a new guest here, Vinnie Politan. He's on Skype. Vinnie, are you there? You've been covering this case for 11 Alive in Atlanta. You're right there. You're covering it every night on your show.
Yeah, we're doing it every night, and This is really a big trial down here, a big case, and a lot of folks were following it from the beginning and watching the evolution. And you talked about the charges. Why is this a murder case? Well, this is one thing I want to put out there, and let's not forget what happened in the opening statement, what prosecutors say they're going to have evidence of, that this defendant had a meeting with someone who was really good friends with the DA and told that friend of the DA, you can make this case go away, and if you do, there's a whole big bonus of money for you, and by the way, I won't mind if you share it with the DA.
Smells like corruption.
Happens, this case is not going away.
Yeah, well, let me ask you about what Arthur said about the criminal returning to the scene of the crime. There's a lot that's been made about this witness tampering, that it's evidence of a cover-up. Do you think it infers his guilt, or was he just acting foolishly?
No, what he did, this is one of two things. This was either an accident that he makes look like a murder, or it was a murder that he tried to make look like an accident. Those are the two scenarios here.
So which do you think it is, though? Because you've been covering this from the start.
Well, there's one huge piece of evidence that I haven't heard yet, and I think this is going to be crucial. And it all has to do with the gun in the bag. And the fact that the trigger pull on this gun when the hammer is cocked and when it's not cocked. From my perspective, what I need to hear from the defense is the only way you can convince me that it's an accident is if the gun is already cocked in that bag. Well, how does the gun get cocked? Who did it? Okay, was it already cocked when it was in the bag in the console and Diane handed it to him that way? Or did he do it in the back seat? And if he did it in the back seat, that gets us a lot closer to murder than it does to some sort of accident here, because there was no immediate threat to them in that car that night. No immediate threat. They went under an overpass. There were some homeless folks there. I've been to the scene there. Yes, there are homeless folks there every night. But there was no immediate threat to this vehicle. No reason to cock that gun unless you were going to fire it.
But that doesn't mean that he didn't imagine that type of a threat, right, Arthur? He sounded like he was a guy who was scared from the start, the second he realized that Danny Joe Carter had taken a detour off that highway.
It's definitely his perception. That's what the judge will tell the jury. It's not. In New York, it's split. It's what the individual believes, but then it's also what a reasonable person would believe. But under those circumstances, it is reasonable for someone to feel intimidated or threatened in some way. I think what Vinnie is talking about, though, is does someone hand someone else a cocked weapon? No. I mean,
but why are they cocking a weapon in a bag? Why would he cock it in the bag, Sandy?
Well, the other part of it is, and I'll talk about that in a second, this neighborhood was not as bad as he claimed it was. And there's some evidence in the trial that it wasn't as bad a neighborhood that should put fear in his mind. And the cocking of the gun is a very serious issue here. And I think that, if anything, is going to lead a path to conviction more than anything else.
Okay, let's toss to a quick clip here now of him giving an interview to police with his attorney after his wife died. Tex McIver.
What's the next thing that you can remember after you got in the vehicle? So Danny was driving, right? Okay.
I was in the back seat.
In the back seat. Okay. And what's the next thing that you can? I know you said you kind of fell asleep there. What's the next thing that you can remember?
I remember the turn going from I-20 onto the connector. Mm-hmm. That's a pretty hard ride.
Right. Yeah.
Guaranteed to wake me up. And the next thing I remember is we're going down.
Okay.
And I knew then that we were no longer on the connector.
Right.
And I came up and I said, girls, where are we and what's happening here?
Right.
Because we were clearly off our path.
Right. And what do you remember after that?
We went through an area I thought that was particularly dangerous at night. I'd seen police vehicles there. It's a route I take from my office to her office. And I quickly said, this is a big mistake and we're in a place that we don't belong.
Right.
And of course here we are in an almost new SUV and two women in the front seat.
Right.
So anyway, they made a couple turns and things were not going well. Diane said, we'll be on Piedmont shortly. And I said, yeah, I'd like to, if you don't mind, please hand me my gun.
Right.
And it was in the center console. So Diane reaches in, pulls it out, hands it back to me. And by then we may have been on Piedmont. Anyway, I'm relatively satisfied that we're out of that kind of area. Right. And I guess I just laid back again and went to sleep. Danny Joe came to a stop, and anyway, I just time to wake up. Anyway, but she came to a stop, and I was handling the gun. And I realized it was in my lap, right, and it went off. Okay.
That's Tex McIver talking to police. Vinnie, we were just talking about how the area may not have been objectively dangerous, but he's giving details to show that he perceived it was dangerous. He had been there before. He had seen police vehicles. He was in a car with 2 females. It was a new SUV. Does that help the analysis that the jury will make about not just whether the area was dangerous, but how he perceived it in the moment?
Yeah, well, let me tell you about the area a little bit, because I've driven it a bunch of times, and actually, I live down here. So it's an area that maybe 20 years ago, 30 years ago, may have been perceived as much more dangerous than it is now. It's a gentrified area at this point. But again, as you get off of the connector, which is our main highway, which runs through downtown Atlanta, it was backed up that night because there was a paving project. Happens all the time down here. So they get off the connector, and then they go down the ramp, and as you make the left onto Edgewood Road, that's when you go underneath the area where there's an encampment of many homeless people. You quickly pass that, and within 2 or 3 blocks, you make that right-hand turn onto Piedmont, and then you're basically driving through a downtown business district, and you're on your way out of the most dangerous, at least the part that he would perceive as dangerous. And he even said that, if you heard him. My question is, though, if you're so alerted and so concerned about the safety of these 2 women, why do you fall asleep again? Because that drive from the time he got the gun to when that gun goes off, again, I've driven Piedmont Road there, it's about 8 minutes without traffic.
Yeah, well, and did he even fall asleep? That's what we're going to be exploring. We don't know. Arthur.
It's just so, as a New Yorker.
You're sitting here smiling. Why?
Well, because it's so foreign for us. Sandy and I like to, this is a bad neighborhood. Could you open up the glove box and give me my gun? Like,
right, well, it's a different culture.
I know, law-abiding people like us, we don't have a gun in the glove box. And then what Vinnie says makes sense. Like, you're going to be, you're heightened. You're going to be alert. Like, let me look what's going on. What's going on. Like, not, let me go take a nap with my gun in my chest. Something doesn't ring true there.
Right, but we know that he did have a little alcohol in his system. So that could have also played a part in him falling asleep. Maybe it made him sleepy.
There's another issue here that we haven't addressed, and that is, if he intended to kill her, why did he do it when there was a witness driving the car?
I was thinking that myself.
Why did he? I mean, that's a great piece for the defense.
Yep, and maybe he will discuss that in the police interview. We're going to come back after this break and watch more of Tex McIver's interview with police. So stay with us on Law and Crime Live. Welcome back to Law and Crime Live. If you're just joining us, we are covering a case out of Atlanta. An Atlanta attorney named Claude Tex McIver accused of shooting and killing his wife intentionally. After he was charged, he gave an interview to police. Was that a smart move? His lawyer was there, but the attorneys that are seated here with me think that it was not a smart move. Let's listen to some more of that interview.
When Danny was looking for, or when she was making these turns, was she following GPS? Was she listening to anything, or just from her knowing the city? Diane's office is very near there, and Diane was directing her. Right, left. So she knew where she was, basically. My dismay was, it seemed like every turn we made, the street was darker, and there were more people milling about. I mean, it was kind of thing that rose the hair on the back of your neck. What do you remember after the gun was off? I immediately called out. I said, "Is everybody all right?" And Danny Joe said yes. And Diane's head was kind of slanted. She said, "I've been shot," words to that effect. And I immediately put my arms around her and tried to determine how bad it was. And then I made the judgment that Emory was the closest hospital. They're a client of our firm, and I care a good bit. So we shot down Piedmont, crossed over Monroe, hit Morningside, went into the ER. Danny Joe driving with me, telling her to go faster. Then when you get to the hospital, you remember what happened next? Never forget as long as I live. As we pulled up to what's the door of the ER, kind of a circular thing, I got out and yelled, "Gunshot wound." And anyway, people were scurrying around, and a gurney comes out, and I help them load Diane. At that point, she wasn't very responsive.
Did you get a chance to talk to the doctors at all, though? Anything that you can recall?
Yes, there was. They brought us into the family room at the ER, and it was a female doctor. She said, your wife's in bad shape, but she's responsive. We asked her, how is she, and so on, and has she said anything? And this doctor said, she said it was an accident. She was on the table about an hour and a half. If you ever want to have the absolute, I'm going to cry. If you want to have the worst feeling in your life, is to be sitting in one of those waiting rooms, two surgeons in scrubs and a chaplain come around the corner and start walking towards me. I actually looked behind me, hoping it was somebody else. And anyway, they took me into a room and explained things to me. And asked if I wanted the chaplain. Did I want to see her, right? All that. Never forget. I'm sorry. No, sorry. Take your time. The love of my life. Anyway, that's what they did. And I went in to see her.
Tex McIver calling his wife, who has just died, the love of his life, and getting emotional. Vinnie Politan, you have been covering this trial out of Atlanta. There's been a lot made of the fact that he was not hysterical, not overly emotional at the hospital. But we see that now in the interview. Do you think that all that evidence was persuasive to the jury, or do you think this is perhaps the way that the man grieves?
Well, did you hear him say, listen, I'm going to cry. Are you guys rolling on this? We got the cameras going, so I'm going to cry right now.
Okay, so you think it's manufactured. You think this is all an act.
Well, to me, just watching it doesn't come across very well. Doesn't come across well. I know the standard defense attorney line. We all grieve differently. But it just seems the ones that are on trial never seem to grieve appropriately. I'm just saying.
So, Arthur Aidala, are you...
That's not true, Vin. Sometimes witnesses don't grieve appropriately. Sometimes there are bystanders or family members that don't grieve, quote-unquote, appropriately. I don't think it's so out of the ordinary to say, I apologize, I'm going to get choked up now, or I'm going to lose my composure. What I think of right there is... of course, I've been a criminal defense attorney now for 20 years after 5 years as a prosecutor, but if it really was an accident, and you really did lose the love of your life, and you really did have that scene with the chaplain and the surgeons that broke your heart, and now you're facing trial of killing that person who was the love of your life, that's amongst the worst things that could probably ever happen to you in a lifetime.
So if the prosecution is going to go down that route of trying to make it like he didn't care because of the way he reacted, and the defense is probably going to say, well, he was in shock, does the defense put him on the stand to show that he is emotional? We see him tearing up in court there. We've seen it throughout the trial, especially in the opening arguments.
That'll be a decision that they'll make probably right at the very end. And again, it's one of those strategic decisions they make. How's the evidence going? How has it gone in? Has the prosecutor clearly proven their case beyond a reasonable doubt, or they clearly have not? Because you never know how a defendant is going to react when they're on the stand.
Here we have another example of a man who may think he's smarter than everyone else and he can talk his way out of it. But there's another piece of evidence here that we haven't mentioned yet that's very significant, even more than his perceived state of mind at the time of this interview. And that is, there's some hints of him having a relationship with someone else. I believe it was a masseuse.
Well, there was a suggestion, but I didn't think that the evidence was substantial.
That would lead more to motive.
Right,
well.
but they didn't. I think they didn't make that the central motive because there wasn't evidence beyond her wearing the dead wife's boots while she was giving a massage. I mean, the fact that she's doing her job and giving a massage, that's not evidence of an affair.
It's once again food for thought for this jury. Economics here, very important for motive, and the possibility he's involved with someone else. Another issue the jury could consider, even though they do have to ultimately make the decision beyond the reasonable doubt with regard to guilt.
Exactly. There's so much speculation here, Vinnie. Wouldn't you say?
Well, Yeah, well, you've got the masseuse and the boots. That's not good for Tex McIver. And don't forget, you have something else. You have the testimony from Diane's personal assistant that just days after he shot and killed Diane, which is a fact in this case, he's talking about Diane's good friend and neighbor and his ex having some trouble with her husband, and maybe he'd get back with her. So there is evidence that he was seemingly moving on pretty quickly after being responsible for the death of the love of his life.
Is that evidence, though, of intent to murder someone, or is that evidence of a man who's lonely and heartbroken and maybe desperately trying to seek some companionship?
State of shock, Vinny. He was in a state of shock. He was grasping at straws.
Vinny, you there? I think we lost Vinny. All right.
Sorry, I was just going to get it. Obviously, Vinny was saying that that's a ridiculous thing, and I will tell you, I do think it's not the typical reaction a few days later talking about your ex. I mean, at that point, you would think someone would just be sitting in a chair, somewhat catatonic, like, what has just happened over the last couple of days, and what do I do next? And especially when you throw in, and the police are still investigating what happened here. I don't think it would be that normal for someone to say, oh, what about my ex-girlfriend?
But here's the thing. They have to prove intent. Though we've seen in plenty of cases that are circumstantial, there has been a victory for the prosecution, sometimes without even proving a motive. Do you think that could happen here?
Well, I think here we have arguments of motive. Motive being the money. She makes more than him. He's $4 million richer after she dies. He had
absent a life insurance policy, couldn't that always be the motive?
He had economic problems at the time. He couldn't pay his bills.
Right.
That's all relevant.
That's
all relevant here. I think at the end, the bottom line is going to be reasonable doubt. Has the prosecution been able to prove this case with enough evidence that a jury will find him guilty beyond a reasonable doubt? And I think that's the whole the defense lawyer is going to go into in summation, that there's no proof beyond a reasonable doubt here.
So do you think that's going to be the defense strategy, to just hammer home reasonable doubt? And will they not even put on their own case because they want to show so many gaps in the prosecution?
It depends on how the prosecutor's evidence goes in. But to what you said a moment ago, I think jurors really do want to hear, in a case like this, they want to hear from the defendant. They want to hear how his heart is breaking. They want to hear how I would never dream about doing this. I can't imagine. It's so hard to imagine my life right now without her. So I think you need to get that sympathy and that empathy into the jury box that you're only going to get if he takes the stand. However, I will tell you, you have to prepare him for weeks, not days, weeks.
This guy.
Because when you're on the stand, the nerves and the pressure and the whole scene is beyond imagination.
Clearly a double-edged sword.
We've already seen that this man overthinks things, that he tries to control the situation, right? He was trying to control what witnesses were saying. So we're going to take a quick commercial break. We will come back with our live analysis of the Tex McIver trial. We are in lunch right now, but please stay with us here. Law and Crime Live on the Crime and Investigation channel. We'll see you right after this. Welcome back to Law and Crime Live on the Crime and Investigation channel. If you're just joining us, we are covering Tex McIver case out of Atlanta, a prominent attorney accused of intentionally killing his wife, though he says it was an accident. I have Vinnie Politan on the line on Skype. Vinnie, you've been covering the case. So this man is seated behind his wife. He says they drive into a bad area. Her best friend's driving the car. He says he's concerned about potentially homeless people in the area. He doesn't think that it's a safe area. So he asks for his gun. It must have been cocked because he accidentally shoots it, though that's still a point of contention. Puts it in his lap, falls asleep, jolts awake, shoots his wife. He says, oh my gosh, this was just a huge accident. You have a demonstration for us. You have a plastic bag, right?
Yeah, I do. And here's the point I want to make. Today, for the first time, I got to really see that plastic bag in court and the holes that were in it. And what's interesting is, if you can see here, the holes are in the bottom of the bag. So the holes are down here in the bottom of the bag.
Just to clarify, Vinny, because the gun was in the plastic bag when it was fired.
Right. The gun's in the bag. So if you put a gun in a bag, right, and you lay it in the bag, which way is the nozzle point? Is pointed out the side of the bag, not the bottom of the bag, okay? So from my perspective, it was pretty eye-opening to me that in order to fire a hole through the bottom of the bag, it's got to be in his hand. The other thing is, it's in his lap. And if it's in your lap sleeping, is your hand going to naturally point straight this way, or is it going to go sideways?
Well,
That's the
also,
part that I'm having trouble with.
is your hand going to hold the same grip if you're sleeping? Wouldn't your fingers fall off of the gun?
You would think, but here's I don't want to point the gun out that way.
I was just thinking that.
This is an
Look at it on the nozzle here.
If they get out of line, I'll let you know.
Yeah, it's an airsoft gun. It's not a real gun. But here's what's going to happen for the defense. And we're talking about who are they going to call? What are they going to call?
Yeah, you have insider information, you said, right? Give it to us first here.
Well, first of all, I don't think Tex McIver is going to testify, but we'll talk about that later. They're going to call a sleep expert because he suffers from some sleep disorder, and I'm wondering how this disorder impacts his index fingers, because that's really the issue here. There's going to have to be some evidence from some expert about some sleep disorders that's going to make you fire a gun, which I think is really potentially ridiculous, okay? That's one witness that they're going to have. The other witness will be obviously their own gun expert to talk about the trigger pull and how when the gun is in fact the hammer is cocked, how it could be less than 4 pounds. It could be a 2-pound pull, which is extremely light versus the 14 pounds double action if it is not, if the hammer is not cocked. So they'll have that expert. Now, there was one other witness, though, that's going to be really interesting, and I want you to keep your eye open for. Yesterday, when they brought the pile of guns into court, some of those guns were confiscated by the sheriff of Putnam County, Sheriff Sills. Great guy.
Vinnie, we lost you again. We'll have him back soon. What do you think about that theory that if you're sleeping, wouldn't your hands fall off the gun and then you jolt awake? Don't you have to grab the gun, point it, and fire it? And also, if you're sleeping, wouldn't the gun fall to a downward position? Why would it be pointed at her back?
Ladies and gentlemen of the jury, the prosecutor is the one who has to prove this to you. We don't. So there's no expert that anyone could call that talks about when this person, when my client Tex is sleeping, where he keeps his hands, what position he has his hands in, if he's startled and he's woken up, what direction his hands are facing, or anything on his lap. Whether it's a gun, a cell phone, his eyeglasses, you don't know. There's too much speculation for you to base your verdict on that.
Are you ready? Are you ready, prosecution? You do prosecution.
Now, ladies and gentlemen of the jury, use your common sense. How can the holes be where they are if that gun wasn't fired intentionally by this defendant? It just doesn't make any sense. Use your common sense.
It sounds like you were on the defense, though. What if
no, that's the prosecution.
Okay.
Prosecution is saying use your common sense. The holes would not be where they were if it weren't for the fact this gun was intentionally fired.
Exactly.
The thing is, a plastic bag is so pliable and slippery, and things can move around in a plastic bag. I mean, I know Vinnie was very excited about that evidence. I would put that back in his face in front of the jury and say, folks, if this is their big piece of evidence about the holes are in the bottom of the plastic bag, then you walk my client out of court right now.
Mm-hmm. It's one piece of a puzzle.
Sure.
And if you put all the pieces together, the motive, the bag, the woman still in the car when it happens, this was an intentional murder done with a plot that was created by this attorney who knows his way around the courthouse.
But Amy, what you said, though, what you said that doesn't make sense, which would lead you to think it's an accident, is he doesn't handle things well at all after the crime.
So how could he be a mastermind?
Exactly. That was your point, and I'm agreeing with your point. You could be on my jury.
And why would there be an eyewitness in the car when he commits this so-called crime?
He's not that good.
But like you said, the jury has to solve this puzzle. I want to toss to a quick package now because there was supposed to be a hearing today. It was postponed, but a very fascinating case that we still want to cover and preview for a couple weeks from now. Newman Raja, he was an officer, a plain-clothed officer in Palm Beach Gardens. He came upon a car. A man's car had broken down on the side of the road. Something ensued, and he ended up shooting and killing the man. Watch what happened.
Police officer Newman Raja faces a hearing to determine whether he can present a stand-your-ground defense to manslaughter and attempted murder charges. He's accused of shooting and killing motorist Corey Jones, who had broken down by the side of the road. Raja was in plain clothes and in an unmarked police car when he pulled up near Jones. He claims Jones pointed a gun at him and that he fired back in self-defense. Prosecutors claim some of the shots came after the victim threw down his gun. Here's how Florida's Stand Your Ground law works. The law eliminates a duty to retreat if a defendant faced an imminent threat of death or great bodily harm, or if the defendant needed to prevent a forcible felony. It applies in a dwelling, residence, or vehicle. In this case, the defense will apply if the motorist posed an imminent threat and if Raja was not the initial aggressor. Florida's Stand Your Ground law changed in 2017. Under the old law, the defendant had to prove Stand Your Ground applied. Under the new law, the prosecution must convince a judge it does not apply. This is Aaron Keller for the Law and Crime Network.
Now, we're going to come back and talk about that in depth, but Sandy, a little wrinkle there is they are trying to apply a new law that may not have been in existence at the time this happened and say that the burden to prove Stand Your Ground is on the prosecution.
The question is, can this law be applied retroactively? I don't believe so. I believe that when a statute is passed, it's going forward, not going backwards. So the key issue here is who has the burden of proof with regard to the issue of whether or not the police officer was in fear for his life. If, in fact, it's the old law, then the burden of proof goes back to the way it used to be, which means that the defense has to prove that. Under the new law, it's a burden on the prosecution. They have to prove affirmatively that the defendant was not in fear of his life.
Which is the
but I don't think it can be. But I don't think it can be applied.
Yeah, we're in Florida.
Right. I don't think it can be applied retroactively. So I think they're going to have to go on the old law, and that's very relevant in this hearing.
So they're taking a shot in the dark here. They're just trying to.
Well, basically, the defense is saying, listen, this is a new law. And under the new law, we no longer have the burden of saying our client had the right to react the way he did. The prosecutor now has to say he didn't have the right. So it's a tremendous difference. It's a huge burden lifted off of the defense and put on the prosecutor.
But remember, this happened before the new law was enacted.
Right, so that's the problem. That's what the judge has to decide, right? Because whoever has the burden has the least favorable case. Right? It's more favorable to the person without the
clearly
burden.
An appeal issue, either way.
In federal court, it's the law at the time of the crime takes place.
Yeah, so however it's settled, you're saying there's going to be an appeal.
And in most state courts as well.
Yeah, so we'll come back and we'll talk about this because guess what? The motorist who was stranded, he called some sort of a AAA or help service, and that audio caught what happened. We'll discuss that right after this commercial break. So please stay with us on Law and Crime Live. Welcome back to Law and Crime Live. Before, we had Vinnie Politan on. He is back. We had lost him for a second. And Vinnie, you were telling us some critical stuff that's going to come out in the Tex McIver case out of Atlanta. That's an attorney accused of killing his wife intentionally, shooting her when he was in the back seat of the car. She was in the passenger seat. You said that there were a lot of guns that were brought out onto the table the other day, and everybody saw that this guy is a gun aficionado. And some of them were confiscated by the sheriff, and you said the sheriff's going to be called to the stand. Why is that relevant?
Well, it's really relevant because who the sheriff is. His name is Sheriff Sills. He is out of Central Casting for a Southern Georgia sheriff. He's a great guy, but is great friends with Tex McIver, okay? And has publicly vouched for Tex McIver early on in this case, saying that he was a good guy and he didn't believe it was murder. But his relevance here is that the defense is making the prosecution call him to the stand because of a chain of custody issue with the pile of guns that were brought into court yesterday. So we should expect to see prosecutors have to call Sheriff Sills to the stand, which gives the defense attorneys an opportunity to ask him some nice leading questions and perhaps get some interesting information in front of the jury that may make the jury like Tex McIver and trust him a little bit better because of Sheriff Sills, who will be an absolute character on the witness stand.
So really the gem of that testimony is the fact that he can speak in endearing terms about his friends, regardless of this whole chain of custody stuff, which really doesn't factor into intent.
Right. It has nothing to do with intent. I think the defense will try to do what they can to get Sheriff Sills to talk about his friend, Tex McIver.
So won't there be objections then?
The prosecution will try to keep it simply with regard to testimony as to the chain of command, as opposed to other questions which may be asked on cross that would be objected to, which go off that path.
Right. You know what? I want to switch gears for a second because you two, you're a civil rights attorney, Sanford Rubenstein, Arthur Aidala, you're criminal defense, but you guys have handled cases that involve police shootings. We have a case now we're going to toss to the package. This is a Palm Beach Gardens police officer. We want to preview it one more time. Newman Raja, in a couple of weeks, the hearing is coming up. He shot and killed a person who was stranded on the side of the road. Did he have good reason to do so? Listen and we'll discuss.
A former police officer who shot and killed a stranded motorist claims it's a classic case of self-defense. He'll be making his case in a stand your ground hearing this week in Palm Beach, Florida. Newman Raja is charged with manslaughter and attempted murder in the shooting death of Corey Jones, a beloved local musician. Jones was standing outside of his broken-down SUV on the phone with AT&T roadside assistance when the defendant approached him in an unmarked car in plain clothes. The defendant claimed in a 911 call the victim pointed a gun at him.
I came out, I saw him come out with a handgun, I gave him commands, I identified myself, and he turned, pointed the gun at me, started running, I shot him.
But prosecutors say the defendant's story isn't the whole truth. AT&T roadside assistance recorded the service call from Jones and showed the defendant may have lied.
And what's the name on it?
Corey Jones.
And what can I do for you tonight?
I need to get a tow. I'm
Okay.
broke down. Stop. I'm good. Yeah, I'm good. Yeah.
Oh my gosh. There's gunshots.
Raja's attorneys intend to use recent changes to Florida's controversial Stand Your Ground law, which requires the prosecution to prove it wasn't self-defense before the trial. I'm Rachel Stockman for Law and Crime.
Wow, that is some evidence. You can hear it all. You can't see it, of course, and we'll discuss that. But, Arthur, you have represented police officers accused of killing people unjustifiably. And, Sanford, you have represented the families of people who have been shot by police. And you guys have faced off against one another, right?
Yeah, it's always a tragedy. Like, in other words, let's just start off, and that's something we definitely will agree upon. It's a tragedy for the police officer who has caused another person's death if it was unwarranted and it was a mistake. I mean, we all work in an industry where if you make a mistake, you could get fired, you could get fined, you could get chastised, but you don't go to jail for life. And police officers work in an industry where if they make a mistake, they can go to jail for life.
Well, it's not quite as simple as that. Police officers need to be held accountable when they break the law and kill someone wrongly. And that's a challenge that exists in our society today. Because I believe the only way we're going to end the problem, and it's a serious problem, of the communities not having faith and confidence in the police, is for them to have that faith and confidence, but only if those who wear the blue uniform, who break the law, are held accountable when they should be.
Here's the big question. Newman Raja says he identified himself as a police officer. We hear on the audio that he did not. Does that mean that he didn't? Does it mean he didn't flash a badge? Does it mean that he was wearing plain clothes and he did not drive up in a police vehicle? He was in a van. But how do you establish that maybe he possibly did identify himself as a police officer, given that audio? Because that says a lot.
Where we started a while ago this afternoon, that all has to do with conversations between the defendant and his attorney and what's believable, what the truth is, what's viable, and, that's something. He also needs to say, if this is accurate, he sees the weapon. Clearly, he must. There's no history that I know of between these two people, right? So you're either saying this police officer is a psychopathic murderer, executioner, or there was something at 3:45 a.m. on the side of the road that triggers his police instincts to draw his.
Was that something, an African-American man with dreadlocks? Was that what triggered it? And if not, what did?
There's other evidence here that's very significant. And the most important part of that evidence is the fact that the gun that Jones had was found quite some distance from his body, which totally upends the argument of this police officer in his defense that all of a sudden he was confronted with a man pointing a gun at him.
Well, that's not necessarily so, because if he's running and he's shot, couldn't the gun go flying, Arthur?
Absolutely, and he could have discarded the gun as he was running. I mean, look, in Brooklyn, New York, when I was a prosecutor, the gun often wasn't found very close to the defendant. The police would see a bulge in someone's waistband. They'd get out of the car. The human being would start running, throw the gun in the sewer under the car, or someone keep running, and he could be caught a half a mile away from where the gun was.
But Sandy, also, we didn't hear a lot of pause between between when he's talking to that operator for AT&T and when he gets out of the car to see who just pulled up? Is it possible that the officer planted the gun, found it in his car, and planted it?
Look, there were a lot of discrepancies here also in this officer's testimony. And that's part, I think, of the reason that it went to a grand jury and ultimately an indictment in this case. But why did it take 2 years for this police officer to start the claim that this statute applies to him, the stand the ground statute?
Yes, but I'm asking you, could he have planted the
beginning.
gun, though, Sandy? Could he have planted that gun
Look, it's
to cover himself?
Of course that's possible. It's possible. But if you look at all of the evidence, the totality of the evidence, his failure to identify himself as a police officer, discrepancies in what he said about what happened, the fact that gun was found some distance from the body, the fact the stand the ground defense hasn't been raised for 2 years, it all goes to look at this case very carefully in terms of holding this officer accountable for a serious criminal act.
Vinnie Politan, are you there? You want to join in on this discussion?
Absolutely, because I want to flip the script a little bit on this whole thing. The person who would have had the best stand your ground argument in this case is Mr. Jones, the victim. He was a lawful gun owner in Florida. Why do we have guns in Florida and a concealed permit? To protect ourselves. He is calling to get some help, right? He's on the side of the road, stranded 3:45 in the morning. A van with tinted windows pulls up. A man gets out of that dressed in plain clothes. A man who doesn't identify himself as a police officer. A man who draws a weapon on him. If at that point Mr. Jones had pulled his gun up and shot and killed that police officer, he had a great stand your ground argument to make, because he was not going after someone. He was protecting himself from a stranger in a van with tinted windows who's approaching him with a gun.
Even if he did identify himself as a police officer, is it not enough to say put your hands up and to shoot somebody because you see a gun? Is that enough?
You have to be in reasonable fear of fatal injury to yourself.
That's the test.
No, it's enough to tell somebody to put their hands up. If you're a police officer,
even if it's a legal gun.
If you're a police officer and you come on a scene at night at 3:45 and you see someone has a fire on the side of on their waist, you don't know if they have a permit in their wallet for that gun or not. You don't know if it's a fellow police officer. The protocol is you identify yourself. But yes, of course, you heard me just say that, Vin. First
you can't get his point across because his audio is cutting it out.
First you identify yourself. Yeah. But yeah, a police officer has absolutely every right to make sure the scene is secure for his or her personal safety.
Pointing the gun at you? Is it enough to just have a gun on your side?
One of the things that's very clear from this audio, and it's audio of the truth, is the police officer never identified himself as a police officer. That's significant in this case.
Mm-hmm.
But no, to answer your question, the police officer, the weapon does not have to be drawn. The fact that there is a weapon on someone's holster, on someone's waist, or where the police can see it on the dashboard, no, the police officer can draw their weapon and say, put your hands up where I can see them, don't you dare touch that gun.
As long as he says, I'm a police officer.
Correct.
Vinnie, to your point before, you know what, actually, we're going to go to a commercial break. Vinnie, I want to ask you about some of the discrepancies with the stand your ground law when we come back. But we're going to go to a quick commercial break, and we're going to discuss this. We have some great guests today. We are still in a lunch break for Tex McIver, so please stay with us. Law and Crime Live, we are airing on the Crime and Investigation channel. So thank you to all of those viewers for joining us. Stay with us, and we'll be right back after this quick break.
Okay, Joseph Santoro, I work for the warrant squad, and you are now under arrest. We know there's warrants out on you. No, I'm kidding. Don't worry, Joe. You got at least 10 minutes before the cops come.
I need a cavity search.
Well, not by me. Maybe the cameraman. You know what? This is totally BS. Literally, with Bill Stanton saying, have a great and safe day.
Bullshit. Welcome back to Law and Crime Live. Here in the studio, I have Arthur Aidala. He's a criminal defense attorney. Sanford Rubenstein, civil rights attorney. You guys have gone head-to-head over these police-involved shooting cases. We were talking about Newman Raja, Palm Beach Gardens police officer who shot and killed a man who was stranded on the side of the road. When he pulled up, this officer was in plain clothes. He was not in a marked police car. Corey Jones, the victim, was on the side of the road calling for roadside assistance. When he saw this unmarked vehicle pull up, he got out of his car. Supposedly, he was holding a gun. From audio captured from the car side assistance program, it doesn't indicate that Newman Raja identified himself as a police officer. Is this guy even defensible, Arthur? But the fact that he didn't even identify who he was before he started saying, put your hands up and shooting at 3 o'clock in the morning.
Well, he's defensible if, in any way, shape, or form, he indicates that the victim here reached for his weapon. So it's a you take the police aspect out of it.
Why? That's critical.
No, but even if you took the police aspect of it, if I'm approaching your car as a civilian and I say, hey, is everything okay? And some guy goes and is reaching for a gun, then yeah, I have a right. Forget about the stand your ground law. Anyway, I have a right to fire at him because I'm asking him, is his car is okay? Why is he pulling a gun on me?
What about the fact, Sandy, that he says, are you good? He says, yeah, I'm good. Are you good? Yeah, I'm good. Really? Really? Is that antagonistic? And does that give him cause to say, put your hands up and then fire?
Well, I don't see any probable cause here to tell him to put his hands up. But at the end of the day, it seems to me clearly in this case there's civil liability. Criminal has to be determined by a jury. And it's very difficult in this country to get a jury to convict a police officer. And that's historical. So,
why do you think that is?
Because I don't think many people believe a police officer wakes up in the morning with the intent to kill another human being. I mean, obviously you have to look at their background, their history. I mean, Sandy had one of the biggest cases in the country of someone who tortured, a police officer who tortured another human being, which was incomprehensible. But for the 99.99% of the time, a police officer wakes up in the morning to do their job the right way, not to go kill another human being. And I do believe they get that benefit by jurors.
Do the officers hold more weight when they're on the stand? And the fact that usually the person that's dead, obviously they can't testify, so they can't give their side of the story. And you also have a lot of the times police training experts who justify the actions taken by the police officer. Does that make our system lean more towards police officers, or is it fair to give them the benefit of the doubt because of what Arthur just said?
I think I would agree there's an imbalance, but there's also a serious issue involving local district attorneys handling these cases, because the question becomes, how can a local district attorney who needs the police and the detectives to make their cases prosecute people who are police officers? And in this state, New York, we have the Attorney General in certain cases involving police-involved shootings, an independent prosecutor, the Attorney General. So that's now the whole area that's up for discussion that has to be discussed, because prosecutors in state court need the police to make their cases.
It depends on who the jury is. If your jury is in a certain area, a certain financial demographic, a certain ethnic demographic, they may feel one way about the police and be very complimentary of them. And in a neighborhood 3 miles away, they can't stand the police. So
and it might be hard to pick a jury.
I can share with you something that came up in the case that was just referred to, the Louima trials. One of the criminal trials of the police officer was an 11-to-1 jury for conviction.
And this is a man who was sodomized by police officers.
And the one juror who voted against conviction said, I would never convict a police officer. So that's a mentality that's real in our society that has to be dealt with.
Yeah, Vinnie, are you there?
Yeah, still here.
Vinnie, we were talking about stand your ground, which obviously gives somebody justification to defend themselves. Is there a fatal flaw in stand your ground when the person who's been shot and killed can't give their side of the story? So how do we know who the initial aggressor is?
Yeah, that's the problem. The good news here for prosecutors is that recording, because the police officer didn't know about that recording when he gave his statement to police at the scene on video saying, yes, I identified myself as a police officer. He knew I was a police officer. That was clear that he never did that, so he lied about it. Now, he didn't wake up that morning intending to kill anyone. This is a case of criminal recklessness, where he didn't do what he was trained to do, which is identify yourself as a police officer. He didn't do that. He approached someone in the middle of the night on the side of the road in an unmarked van with tinted windows.
We lost Vinnie again, but you know what? There's an argument to be made that if you act out of color of law, you are guilty of murder. There is an argument to be made in terms of that, right, Sandy?
Look, bottom line is juries make these determinations, and we have to rely on the jury system as the best system that exists. What we have to deal with in this case, ultimately, will be the jury trying to decide if beyond a reasonable doubt they can convict this police officer. Let's see what the rest of the evidence shows.
Okay, so now we want to just go back to our coverage of Tex McIver, an Atlanta attorney who is accused of shooting and killing his wife intentionally. He was in the backseat of the car. She was in the passenger seat. He claims that he was in a scary area. He asked for his gun, fell asleep. He says when he woke up, he accidentally shot her in the back. Right now, we are listening to a firearms expert in court. So let's go to that live trial testimony.
The spin on the bullet. If you see right here where my thumb is, this is the breech face. This is kind of the back of the gun, and this is the part. This right here, the rear, this is the breech face. It's the part that the cartridge case is, when on recoil, the cartridge case is going to slam up against the back of the gun. The firing pin is the part that strikes the primer, and you can see here that it's just barely sticking out the breech face. That's the part that hits the primer, which crushes it, creates the spark. The firing pin is actually attached to the hammer, which is on the rear just above the grip, and it rides inside this shroud, which kind of protects the hammer, prevents it from snagging. And then here you see the front sight and then a rear trench that acts as the rear sight.
Okay. And you described the hammer is contained within a shroud. Can you tell the jurors with respect to this make and model gun, which by the way, if you would share with them what that is?
Okay.
Why, my next question is, what is the significance, if any, of the hammer being contained within that shroud?
Okay. Well, this is Smith & Wesson Model 638, 38 Special. The shroud is designed to kind of protect the hammer to prevent it from snagging. So if you were to pull this out of a pocket or something, that shroud would kind of allow the fabric to ride over the hammer instead of maybe catching on it and preventing it from being drawn. But it also is going to do a couple of things. It's going to protect the hammer if it's dropped. It just kind of hides it, gets it out of the way a little bit for whatever purpose.
Okay. And can you tell the jurors this weapon in particular? Do you have any opinion about whether or not it is designed for self-defense or protection in any way? And explain that to them. Okay,
so this particular model is geared more towards self-defense. The reason being is it's very small. It's got a short barrel, short sight radius, which is going to make pinpoint accuracy more difficult as opposed to a gun that would have a longer barrel and more adjustable sights that would be geared more towards target shooting. So this would be more of a self-defense type gun.
Okay. All right. Thank you. So can you tell the jurors, again, I know you were talking to them and you were showing them the handgun, but in common layman's terms, what is a cartridge?
So the cartridge is the single unit of unfired ammunition. This is the part that if you went to the store to buy ammunition, you would buy a box of cartridges and then you would take them out individually and load them in the gun.
Okay. What's the casing?
The cartridge case is the cup that is left over after you fire the gun. So it's the part that has the primer in the bottom and the gunpowder inside the cup. And then if it was unfired, it would have the bullets seated in top. Once it's fired, the gunpowder burns up and the bullet leaves, and the cartridge case is what's left over.
What is the bullet?
The bullet is the projectile, the part that actually goes down the barrel and out of the gun on towards the target.
Can you open the package that contains, well, strike that, question. Better question. When you received the gun, what condition was it in? Meaning, how were all the parts that you removed from the box, how were they in the box? You understand?
The firearm was unloaded, if that's what you mean.
Yes.
You're listening to a firearms expert. He just did a demonstration to show the jurors how the gun that Tex McIver used works. We will be back with more live testimony and discussion right after this commercial break. You are watching Law and Crime Live on the Crime and Investigation channel. Stay with us, please. Welcome back to Law and Crime Live. We are listening to firearms expert demonstrate how this gun could have possibly been fired by Tex McIver. He's an Atlanta attorney accused of shooting and killing his wife when he was sitting behind her in the backseat of the car. Her best friend was driving. He took out a gun because he says he was scared about the surrounding area, claims he fell asleep. And when he awoke from a sleep disorder, he says that it caused him to fire this gun into his wife's back. I'm here with Arthur Aidala, criminal defense attorney, Sanford Rubenstein, civil rights attorney here in New York. There was a request to the judge that the jurors be allowed to fire the gun, to see how easy it is to fire a gun that's cocked, how much force it takes to try to determine whether he could have accidentally shot his wife. It was denied. Why would they even ask for that?
Prejudicial.
That's the reason
the
it would
judge
be
probably
denied.
felt it was prejudicial because the exact way the gun was in the car at that moment may not be exactly duplicated. So the judge probably felt, I don't want to make an error. It's going to be an appealable issue. If there's a conviction, I don't want this conviction thrown out because I made a mistake. And he erred on the side of caution and said, it's prejudicial, I'm not going to allow it. But there's other ways to get that in, particularly when the trial is still ongoing and questions can be asked specifically of the witness, in this case, this witness, exactly as to how the gun has to be cocked before it's shot. And they can make the same point, I think, as the jurors playing with the gun.
But it's not the same, right, Arthur, as you actually filling it out yourself. That gives you more of an indication. And I've said this before, it could backfire, pun intended here. It could go either way because each person could have a different subjective account when they're firing it of what could have happened.
And I think that's, you just hit the nail on the head. I think that would probably be the judge's thinking. Like, two people sitting side by side may feel different about the exact same thing. Here, what you saw happen was an expert witness. He stands up, he gets in front of the jury box. I think jurors eat that up. He holds the gun, he points it. He has that machine that measures, the measuring tool of how many pounds per square inch. And I think the judge says, listen, that's good enough. You're hearing an expert who's explaining to you how this works. Ultimately, I think this really comes out to, was the gun cocked before it was handed to him or not? Because the amount of pressure that's necessary is 10 times more if it is not cocked.
But how can we ever know that, Sanford?
Well, that's going to be a question of fact for this jury to decide when they ultimately determine their verdict. And there's going to be evidence put to them by both sides with regard to that issue, and they're going to make that determination. Remember, the jury is the finder of the fact, and the facts are going to be the way the jury finds them.
And it may be if he testifies, like we don't know that, but maybe if he testifies, he may say, listen, I had a habit of always keeping my gun cocked in my glove compartment. That's just what I did. I knew that if I really needed that gun, I was going to need it in a moment, and I didn't want to have to wait for anything. You don't know what he's going to say if it ever comes down to that. But Sandy's right. It comes up to a jury then evaluating his credibility. To believe this guy is saying, or is he just making it up because it's convenient?
And it'll be interesting to see if he does testify, because I could see another case where the lawyer may be saying, I don't want you to testify, and he's going to say, I want to testify, and I think we've seen that in Washington recently.
Let me ask you about something with him testifying, because you've actually represented some people who are part of the Black Lives Matter coalition, right?
I represent
Advocates.
now Hawk Newsom, the president of Black Lives Matter Greater New York.
Right.
Who, as a matter of fact, was arrested last night at a demonstration with regard to what happened in Sacramento here in New
Wow,
York.
so I'm sure you will be helping him with that case. But let me ask you about, so with this case, there was some mention that we might possibly hear from Tex McIver's PR person that Tex McIver told him that he thought there were Black Lives Matter people, in the people who were part of this organization, in the area that they were driving through. And that was one of the reasons potentially that he reached for this gun. If he gets up on the stand, he would leave himself open to that line of questioning where they could potentially try to establish that he's a racist.
Exactly. And not only is he a racist, what's the composition of the jury? And how will the jury react to someone who says Black Lives Matter, danger, which is racist in my view?
And I know there are 3 black people in the jury.
So it's a very, very tricky issue that has to be dealt with, particularly in determining whether he's going to testify or not.
Yeah, could that be fatal, Arthur?
It could be if you 3 people. If 3 people go in the wrong way, go in the wrong direction, and they don't like him, not based on the evidence, based on what he says, yeah, it could hurt a defendant tremendously.
Arthur, I know you have to go. Thank you so much for being with us.
Thank you. It was an
Arthur
absolute pleasure.
Aidala,
It was
criminal
beyond
defense
with
attorney.
all of you.
Thank
Thank
you.
you.
We're going to go back to court because they're talking about, right now, a firearms expert is talking about the gun potentially going off accidentally. Critical testimony, so let's listen.
You don't like dirty hands?
It was the form of the question, but you can move on.
Okay. Do you have any opinion with respect to the recoil for this gun?
Well, this is a lightweight gun with a short barrel, so that tends to have more recoil than a heavier gun with a longer barrel.
Okay. More recoil.
Yes.
Would you have any opinion of what you would expect to see with respect to recoil on this gun if it were fired in a lower position like here in your lap?
So could I make an objection and come inside for this?
Sure.
And we are listening to a firearms expert, Zachary Wetzel, and he just did a demonstration for the jurors about how the gun could have fired. There was a request that the jury be able to pull the trigger themselves, that they be able to test it out, to put themselves in the shoes of Tex McIver. That was denied, but they did have the opportunity to see this firearms expert handle the gun and fire it, and how easy it is to do that. There is a sidebar now in court. I'm still here with Sanford Rubenstein. Arthur Aidala, you are still here. You were about to leave, but you couldn't get out in time.
Not a problem.
So we've got you stuck here with the sidebar.
It's interesting stuff right here, actually, in this part of the. I mean, this is the crux of the whole case, right?
Yeah.
I mean, you have an expert who really doesn't have an axe to grind. He's not going to jail. He's not going to jail. He doesn't know anybody here. So he's the one that the jurors, to some degree, are going to rely upon. And don't be surprised if you hear from another expert, if necessary, to contradict what this expert is saying if it doesn't go well for the defense.
You had told me you think this is fascinating to the jurors. Sandy, I know you said that these types of demonstrations are effective, I would assume. But is it also confusing to the jurors? Do you think they can wrap their heads around this level of detail about the gun? There's so much to go over.
It may very well be. And I think this judge is erring on the side of caution. He doesn't want an appeal. He wants whatever happens in this trial to stand. So he's saying, you know what, there's enough evidence with regard to this issue that can be presented before the jury. They don't need to actually physically handle it.
But, you know, Sandy, that could also give, if it was the defense request that the jury handle the weapon and it's denied, that would be a big issue for appeal if he gets convicted. So.
Okay, we're back in court, so let's listen to that live testimony.
Let's look at the casing. Okay. And can you tell the jury, when you, actually, why don't you show it to them? Can you show the jurors, what is that indentation on the bottom of the case?
Right, so in the circle, in the bottom of the cartridge case, there's a little impression there. See it? That.
You can walk around to the side so it pulls up the top.
Good. So this is the impression that the firing pin makes when the hammer falls forward and strikes that primer.
Okay. And can you tell the jury?
You're watching live testimony, a firearms expert talking to the jurors, explaining all about the firearm that was involved in this shooting. We'll be back right after this quick commercial break. You're watching Law and Crime Live.